or sign. Now it's off. We're not getting anything from you, Robert. We're getting a scratchy sound. Can't tell if it's your voice or something else. While we're waiting on Robert, Ms. Hillis, you want to give us a test?
Good morning.
Good morning. Say a couple more words.
Yes, Lindsay Hillis here on behalf of the taxpayers.
All right, we hear you fine. And Bill, can you hear us okay? You want to do a test?
Yes, sir. I can hear you just fine.
And you're coming over great. Alex?
I can hear you just fine also. Thank you.
Okay. So we're still trying to get Robert fired up here. Robert, your mic's not working,
Yes.
but can you hear us through your headset? If you can, give me a thumbs up. Yep. So you're hearing fine, it's just the mic is not coming through.
Should we try to get him to call in?
Let's try this first. Why don't you take the headset off and let's see how you are this morning and the mic and see how that works. And if not, we may have you call in. All right, say a few words, Robert, to see if we get you. Robert, can you say a few? I believe you are saying a few words, but we're not hearing anything. We'll give you a little bit of time. While you're doing that, let's go ahead and we'll officially start. And let me introduce everybody. We'll convene today's Wednesday, December the 9th session of the North Carolina Property Tax Commission. I'm Bob Hunter, Chairman of the Commission. And with us in the hearing room this morning, behind me is Vice Chairman Terry Wheeler, and to my left is Commissioner June Michaud, and in the far back is, to my left, is our General Counsel and Secretary, Stephen Pelphrey. Also in the room is Alexandra Bendette, who is our staff person and also operates our WebEx. And joining virtually is Commissioner Bill Peasley and Commissioner Alex Guest. And we also have our court, well, not court, but our commission stenographer, Linda Garrett. And we have several cases for motions today, all from Mecklenburg County. We have P&L Coliseum LP, 20 Property Tax Commission 0241, the county, Mecklenburg County, represented by Mr. Adden, who's been online, but trying to see if we can get audio. We've had video with him. And then the P&L Coliseum LP is represented by Lindsay Hillis. And then companion cases, I understand, P&L Coliseum Residential Developer LLC, 20 Property Tax Commission 0240. Also a motion to dismiss, and POP Capital Towers LP, 20 Property Tax Commission 0239. Again, motion to dismiss. All these three cases, Mr. Adden represents Mecklenburg County, and Ms. Hillis represents the appellants. Later on this morning, we'll have a motion to dismiss also from Mecklenburg County, Royal Panthea LLC, 20 Property Tax Commission 0237. Will be a motion to dismiss. Mr. Adden will appear for the county, and I understand the appellant is appearing pro se, and I think that will be Ms. Wingate is involved with that. We had two other cases on for today, and that was Carolyn Hoopus, 20 Property Tax Commission 0195. The Mecklenburg County has been settled, and John L. Lacard, 20 Property Tax Commission 035, has been settled, and that was from Mecklenburg also. And so I assume some of those settled cases are in this stack for me to sign over here a little later. All right, Mr. Adden, you're back on video. You want to try again to see if we can hear you? If you hear me, Mr. Adden, give me a thumbs up. And I don't think he's hearing. All right, we'll give a couple of seconds here, or minutes or whatever. Obviously, he's a key person in the hearings this morning.
He's calling me right
All right, he's calling Stephen, so we'll see.
Mr. Chairman.
Yes, Mr. Peasley.
Yeah, the stuttering of his camera and the movements, and also the sound issues, that's is usually a bandwidth issue again.
And we're,
and we can get you the call in. I can call that number. We may be able to call you. It's okay if you go to the phone number. They'll have you in that way and still keep your video.
Steve, tell him that Mr. Peasley thinks it may be a bandwidth problem, and see if there's any way he can increase his bandwidth by getting somebody else off or present anybody else on.
Sorry.
Bill thinks it's a bandwidth issue possibly, and if he's got anybody else on that internet call or using that internet, that if they could get off, it may help. That was Bill's suggestion.
They can get off temporarily. Increase your value.
Yeah, and the alternative, he could call in. I mean, the audio is the important part.
I understand.
We're working on the call in right now. If it doesn't work, for his bandwidth to change.
Yeah, and just leave your camera on. Okay, thanks. Bye-bye.
Can you put him through those speakers, Alexandra? If he calls in the number, can you put it through the speakers or? Okay. Must be the problem with Mr. Adden must be the computer as opposed to his internet as opposed to just the audio, the video problems we were having yesterday. I guess you're right, Bill. Not enough bandwidth for the video, but apparently the audio is not. And his video is kind of shaking too.
And generally from one location, you have multiple people using the same bandwidth, and if it's insufficient, it's kind of like if you're trying to stream something on your laptop and have the TV on, and you have kids, it just can't handle it.
Okay, you there? Can y'all hear me?
We hear you.
Can
Yep.
y'all, can you hear me?
We
I
hear
don't know
you.
what's the problem. I'm not a computer geek, but I went out and got a microphone and headset and everything yesterday and came into the office, so we shouldn't have a problem with the bandwidth. But I don't know. Something's going on. We need to test it out after y'all finish today.
Okay.
Your computer person and me. This is ridiculous.
Well, and we'll be online in the morning. If you want to try to test it in the morning, we can do that also if you want to. If you want to join, we'll be here at 9. We've got one matter. I think it's a motion to dismiss from Wilkes County. So at 9, if you want to try to get in, that'll be fine. But we can make do on this.
Yeah.
Let me ask the other parties, can all the other parties hear Mr. Adden? Could you hear him? Just saying, if you can, give me a thumbs up. All right, Alex, you hear? Yep, I see your thumb now. Okay. All right, I think everybody said they could hear Mr. Adden, and I assume everybody can hear me okay, and the other commissioners or the parties will unmute, and we'll be able to hear them at that time. All right, Mr. Adden, Ms. Hillis, with the, I understand the 3 cases, the first 3 cases, and we'll call them the 20 Property Tax Commission 0241, 2040, and 239. We'll call all those at one time since the issues, I believe, are similar in those cases. Is that correct, Mr. Adden and Ms. Hillis?
Yes, that's correct. There's one slight difference on the pop capital that I'll let you know.
Okay. Ms. Hillis,
Yes.
okay to hear all 3 of these at one time rather than doing?
Yes, that's fine. There's a couple slight differences, but generally it's all the same major issue.
Okay, and y'all can point out the differences then. All right, Mr. Adden, on your motion to dismiss from Mecklenburg County?
Okay, thank you. These are all on motions to dismiss for untimely to the PTC. Attached to each motion is an affidavit from Brooke Millard with South Data, who did the date of testified as to the date of mailing. The BER decisions were dated March the 2nd, 2020. They were all from hearings that were held on February 18th, 2020 before the local board. According to the affidavit of Ms. Millard that's attached to each of these, and they're actually 2. I submitted just last week a second affidavit from Ms. Millard. The taxpayers are represented by Property Tax Consultants, which is a tax rep company out of Atlanta, and they were represented by that company at the local level. The BER decisions were mailed not only to the taxpayers at their address, but were also mailed to Property Tax Consultants with regard to the P&L Coliseum case and the P&L Coliseum residential case. The Pop Capital case, the decisions was only mailed to the taxpayer. The taxpayers received these decisions. The affidavit from Ms. Millard, her response, Ms. Hillis disputes the affidavit from Ms. Millard, saying that it's not a valid affidavit. It doesn't show that the board mailed the decision. As the PTC knows, the county assessor is the clerk to the local board of equalization and review. And the county assessor contracts with a company called South Data for mailing decisions. In this case, I think there were over 4,000 pieces of mail that South Data ended up mailing back in March. Ms. Millard is with South Data. She's a project manager. Her job description is to oversee the mailing of documents for the assessor's office, including the mailing of notices of decision for the Board of Equalization and Review. South Data received the batch of BER decisions on February the 27th, 2020. These are BER decision letters dated March 2nd. They were printed, they were reviewed, and they were mailed out. And they were actually mailed out on February the 28th. But they were dated March 2nd, and so for purposes of these motions, the date of mailing would be March 2nd. There's no question that they were mailed out. There was no question that they were actually received by the taxpayers and by property tax consultants, because on March the 30th, 2020, property tax consultants prepared a notice of appeal to the PTC. Now, again, the mailing date was March 2nd, so the 30-day deadline was April 1st. And we know from the AV-14s that were filed in these three cases that that Ms. Hillis and property tax consultants had copies of the BER decisions because they attempted to file notices of appeal with the PTC. I understand from an affidavit that Ms. Hillis has that they took the notices of appeal to the post office and mailed them on March the 30th, I believe is what the affidavit says. But the problem was they did not send them certified mail, so they do not have a postage receipt of mailing. And for some reason, the U.S. Postal Service did not postmark the envelopes. And as the Commission well knows, the statute requires that if they do not file if the envelope is not postmarked by the U.S. Postal Service, then the date of filing is the date received by the PTC, which in this case was April the 6th. So they were actually filed on April 6th, and the deadline was April 1st. And again, property tax consultants, on their AV-14s that they filled out, they attached copies of the BER decisions, and those BER and those AV-14s were dated March 30th. So there's no question that they had the decisions, and had they done so properly, filed these things properly, then they would have been timely. But the envelopes were not postmarked, and therefore the date of filing is April 6th, and they were late. And the law is very specific on this. Now, in her response, not only does Ms. Hillis attack Brooke Miller's affidavit, but her affidavit is clear. The final sentence of her affidavit says, "These records confirm that the date of mailing of the attached notice of decision was February 28, 2020. It's clear. That's not in dispute. So she attacks Ms. Miller's affidavit. She then, in her response, Ms. Hillis states, well, notwithstanding that they timely mailed the notices of appeal because they mailed them on March the 30th, and they have an affidavit from an administrative assistant for the tax rep that says she went to the post office and placed them in the mail. And I don't dispute her affidavit that on March 30th she took them to the mailbox or took them to the Postal Service and mailed them. But the law is clear. They have to be postmarked by the U.S. Postal Service. And if the Postal Service did not postmark them, then they are deemed to be filed when they are received, which was on April 6th after the deadline. The final argument that Ms. Hillis makes in her response is that the Property Tax Commission is a trial court, and that as a trial court, all deadlines for filing documents were extended by the Supreme Court of North Carolina with regard to emergency orders issued with regard to the COVID-19 pandemic. And I submitted earlier this week to Mr. Pelfrey a copy of a decision from the North Carolina Supreme Court called In Re Twin County Motorsports, Inc., a 2014 case. And in that case, the court distinguishes from trial courts, the Office of Administrative Hearings, the Property Tax Commission, hearings before the Department of Motor Vehicles. Those are administrative agencies that have some judicial-like powers, but they are not trial courts. What the taxpayers, Ms. Hillis's argument is that the emergency orders for COVID-19, she tries to say that they extend to the Property Tax Commission. And she attached copies of all those emergency orders to her response. And if you go through those emergency orders, the first order, the Chief Justice states in her first order, which is Exhibit B to Ms. Hillis's response, the Chief Justice states, although the superior courts and district courts remain open, additional action is necessary to reduce the spread of infection. She's talking about the superior court and the district courts. The order provides that all pleadings, motions, notices, and other documents and papers that were due to be filed in any county of this state on or after March 16, 2020, and before the close of business on April 17, 2020, in civil actions, criminal actions, estates, and special proceedings shall be deemed to be timely filed if they're filed before the close of business on April 17. In other words, the Supreme Court's order deals with civil actions, criminal actions, estates, and special proceedings before the trial courts. The Supreme Court order even states that this does not apply to the appellate courts. It only applies to the trial courts. And at the end of the order on March 19, 2020, Chief Justice Beasley states, additional emergency orders may be necessary to support the continuing operation of essential court functions. Nowhere in this order or any of the other emergency orders does Chief Justice Beasley refer to the Property Tax Commission. Does she refer to matters before the Office of Administrative Hearings or matters before the Department of Motor Vehicles? All of these orders, you can go through each one of them, and they talk about protections necessary for the trial courts. Talks about protections necessary for the courthouses throughout the state. These are all court functions, but they're trial court functions, superior court and district court. And as the Twin County Motorsports case states, the Property Tax Commission is an administrative agency. An administrative agency is not a trial court. In the Twin City Motorsports case, the issue had to do with whether a corporation had to be represented by an attorney at law with regard to a proceeding before the Department of Motor Vehicles. And the Supreme Court says, because we've determined that a hearing before an administrative agency is not an action or proceeding, we hold that a non-attorney may appear and proceed on behalf of a corporation before an administrative hearing officer without engaging in the unauthorized practice of law. And the Supreme Court states in this case that an action or proceeding requires a court of justice, and then that an administrative agency though empowered with limited judicial authority, is not a court of justice. That's on page 6 of 7. An administrative agency is not a court of justice. And then the Supreme Court further notes the 2014 change in the statutes that the Property Tax Commission specifically allows a corporation to be represented by a non-attorney. A corporation, an LLC, can be represented by an employee of the corporation or by a managing member of an LLC. So the Supreme Court states in the Twin County Motorsports case on page 6 of 7, we further note that our conclusion that a non-attorney may appear before an administrative hearing officer without violating NCGS 84-4 is in line with recent legislative action. The North Carolina General Assembly has recently provided that in contested cases before the Office of Administrative Hearings and in appeals to the Property Tax Commission, a business entity may represent itself using a non-attorney representative. The passage of this legislation is consistent with the conclusion that a non-attorney's appearance before an administrative hearing officer doesn't constitute the unauthorized practice of law. So if the Property Tax Commission was a trial court, if the Property Tax Commission was subject to the emergency orders of Chief Justice Beasley, then non-attorneys could not represent or appear on behalf of corporate and taxpayer entities. They would have to be represented by attorneys, but that's not the case. So it's just the fact of the matter is that the taxpayers, the BER decisions were mailed to the taxpayers. They were mailed to the representative for the taxpayers in the P&L Coliseum case and the P&L Coliseum residential case. The representative for the taxpayers, property tax consultants, had those decisions and had ample time to appeal them within 30 days to the Property Tax Commission, and in fact took action to do so. But for the fact that the U.S. Postal Service did not postmark these envelopes. If they had postmarked them, these would be timely appeals. But the law is clear. If they aren't postmarked, they are deemed filed the date received, and they were received after the 30-day deadline, and therefore they should all be dismissed. Thank you.
Ms. Hillis, we'll hear from your response.
Good morning. Lindsay Hillis here again on behalf of the taxpayers in each of the 3 lawsuits. Mr. Adden is correct that General Statute 105-209E is clear. It says that the taxpayer must file its notice of appeal within 30 days after the date the board mailed the decision. Now, there's problems with this Millard affidavit. In the beginning of it, she says that the affidavit is based on personal knowledge, but then it also says based on the business records of South Data, a non-governmental third party. And in that affidavit, in order to get there, she relies on a screenshot that says that 4,298 pages were mailed on February 28th. The problem with that is that she doesn't meet the standard of the North Carolina Rules of Evidence 8036, which would be the hearsay exception. Without meeting a hearsay exception, anything of hearsay is not admissible. And so 8036, in order to meet the business record exception, Ms. Millard would have to confirm in this affidavit that the screenshot and that the indications of when things were mailed were prepared at or near the time of the act, that they were prepared by someone with information and knowledge of those acts, and that these records were kept in the ordinary course of business. The affidavit that was provided does none of those things. And without that affidavit, there is no the county can't say that it was after, that the notice of appeal was filed after 30 days. Plus, North Carolina General Statute 105-322 does not grant the Board of Equalization and Review the authority to delegate its duties to mailing its third-party decisions. There is some right to delegate certain duties, like help with appraisals, but there's no right in 105-322 to delegate mailing of its decision. Notably, in most counties, the board is signing a certificate of service saying the day they mailed it. There is no such information on that decision because they're not doing that. And also on the Pop Capital, on the 239 PTC 239 action, the Mecklenburg admits that it never mailed the decision to the agent that it was requested to mail it to by the taxpayer. That just simply never happened. And the statute is very clear that it says the date mailed by the board. And if that date, the board never mailed it, then the time never started to run. And so they want the statute strictly construed against the taxpayer, but do not wish to face the same fate. They only want it strictly construed one way, not strictly construed both ways. Now, again, the affidavit in the record from Property Tax Consultant's office is that the notice of appeal was taken to the post office and handed to a U.S. Postal Service employee on March 30th at 3:37 p.m., 28 days after the date on the notice of appeal. So it was timely delivered in the hands of the U.S. Postal Service, which is distinguishable from any other case that is out there on motion to dismiss standard. In all those cases, they postmarked it in the office and they put it in a mailbox, they put it outside. There is no case where they actually physically took it to the post office and handed it to a U.S. Postal Service with request to postmark. That is what happened here.
Can I ask a question, Mr. Chairman?
Sure, Commissioner Whittier. Vice Chairman.
Ms. Hillis, this is Commissioner Wheeler. I was noticing this before you just mentioned it about personally delivering it within 30 days on March the 30th at 3:37 p.m.
Yes.
In fact, the document we have here that we received has a Pitney Bowes postal date on it, not a U.S. Postal Service.
Yes, that's true. She got confused on to which packages were supposed to be where. She postmarked it in the office, but then physically took everything to the post office and handed everything to them and asked them to put their U.S. Postal Service stamp on top of it. Unfortunately, she was new and she asked them to postmark it on top of it, which they regularly do. But in this case, for whatever reason, they did not.
All right, so it does not have a U.S. postmark on it. It's got a Pitney Bowes.
It has a Pitney Bowes, correct?
Okay, thank you.
Now, back to the issue about the emergency orders. The PTC on its website and its handbook all says this is a trial court. In fact, the North Carolina Court of Appeals, in a decision with Mecklenburg, it was in the matter of appeal of Harris Teeter LLC, North Carolina Appeals 2020. It doesn't have the full site yet, but it was Court of Appeals number 19-927. In that concurrence, they say, look, the PTC is a trial court. If the PTC is a trial court, then all of these orders from the judicial emergency orders extend the deadline. Now, there is some ambiguity in those initial orders, but if you were to look at the May 30th, 2020 order that was attached to our brief, it says in any manner. It doesn't specify anything about civil proceedings or criminal proceedings or anything. It says in any manner in which the deadline to file a notice of appeal fell between March 13th, 2020 and June 1st, 2020. The deadline for filing such appeal and making any required payment for bond is extended through June 30th. So if the notice of appeal for any matter in the state of North Carolina is extended through June 30th, then there's no question that our notice of appeal was timely. Now, it sounds like Mr. Adam this morning was saying, look, it's not a trial court. It's an administrative proceeding. Administrative proceedings were also extended. We also gave that order in our motion. Yeah, they were extended likewise well past April 6th. And again, we have recently learned and would ask that this body take judicial notice that the PTC, that its office was officially closed the week of March 30th because of a COVID positive test. And so if we're being held to the date that it was physically delivered to the PTC, then that's a problem because no one's checking the mail every day and file stamping them as they normally would. I mean, all in all, date all of this happened.
Well, let me
Fulton
ask,
County, where,
I'm sorry.
Just a minute, I believe Mr. Commissioner Peasley wants to ask a question, Ms. Hillis.
Yes, please. So you're saying that the PTC office was closed due to a COVID positive test? Is that what I'm hearing?
yeah, my understanding is the entire building was closed that week because of a COVID positive test for cleaning. And so no
Okay.
one was there to physically receive and stamp the mail.
Okay. What evidence do you
And
have?
so
of
if we're
this?
stuck with, so we've tried to get the PTC to confirm it, but we haven't had any luck doing that. But my understanding from press releases from the office is that is the case, and we believe you can take judicial notice of your own closings.
Did you? Okay. Did you give notice to the other side about that issue?
No, we just learned of it yesterday.
Okay. Thank you.
Now, so at the time that all of this happened, Mecklenburg County, Wake County, and where the taxpayers reside were all under stay-at-home orders. Which is why North Carolina, through its governor, its Supreme Court, its Office of Administrative Hearing, and the North Carolina General Assembly have extended deadlines. You can look at all of those orders, the Office of Administrative Hearing, Senate Bill 704, all of these things were in place so that taxpayers would not have to risk their physical safety to travel to the post office and do these things within the time period. And because most offices were closed and decisions were delayed. And at the end of the day, the affidavits that are put into the record of Ms. Milner do not show that the documents were mailed on or about May 2nd. Now, I will point out that with the affidavit that Mr. Adam gave us, the second affidavit he gave in section 241, in case 241, it's interesting because the decision that he attaches claims to be dated February 28th and claims to be mailed February 28th. But the decision that taxpayer ultimately received in the mail was to the same agent, but was dated March 2nd. And it's all using the same screenshot. So with all of these documents being conflicting, it raises the burden that these affidavits are unreliable, especially when it doesn't meet the standard of the business records exception. So if you compare the Exhibit 1 that's attached to the affidavit on my response from Ms. Joanna, and then you compare that to the second affidavit that Mr. Aiden submitted, they both say that they were mailed to Jay Hembury, and one is dated February 28th, and one is dated March 2nd, and the affidavits are conflicting because it says that all these letters were dated March 2nd. So without all of the foundational allegations in the affidavit, we don't believe that these documents are properly authenticated as to the date of mailing. And without the date of mailing, then our notices of appeal were timely. Thank you.
All right.
Mr. Chairman?
Yes, Mr. Peasley.
Yeah, I had a question. In the taxpayer's response on page 5, I just want to make sure I'm looking at what is a typo. The first line says, "Thus the order extending deadlines entered by the Georgia Supreme Court applies." Is that
Yes.
Okay. I didn't know if there was something.
No, Georgia, that's my primary practice location, so that was just a pure error.
Okay.
On my part.
No, well, it happens. So, but I just wait, was there something I was missing? So, all right. Thank you so much.
Thank you.
Mr. Adden, you want to respond to Ms. Hillis's the issues that she raised, and we may have some questions.
Yeah, just briefly, I was under the impression from the affidavit that Ms. Hillis submitted that mailed these just with stamps, and the stamps just didn't get postmarked. But it's not privy to the envelope that the Property Tax Commission received, and apparently it appears that the property tax consultants, the tax rep, mailed the notices of appeal on March 30th using a Pitney Bowes stamp, postage meter stamp, and as the Property Tax Commission well knows, under the Bass case, Pitney Bowes stamp is not sufficient. That if you use a Pitney Bowes stamp or any other non-U.S. Postal Service postage meter, then it is deemed filed on the date received, which would be April 6th. And again, the evidence is clear that this is, they had the decisions. They tried to properly appeal the decisions. They just used the wrong process by mailing them with a Pitney Bowes stamp instead of a U.S. Postal Service.
Mr. Chairman.
Yes, Mr. Peasley.
Yeah, Mr. Adden, what is your position with regard to us taking judicial notice whether the Department of Revenue and resultingly the Property Tax Commission was closed on or about the April 6th?
Well, the magic date would be April the 1st. The fact is that they did not even try to personally deliver them to the Property Tax Commission. There's no evidence that they even tried to personally deliver them. Ms. Hillis and the tax rep is in Atlanta. The evidence is what they tried to do was they tried to mail it, which is perfectly legitimate way to file an appeal if you do it properly. And if you're going to use a Pitney Bowes stamp, then it has to arrive by April the 1st. If you're going to ask that the post office physically postmarks the envelope, then you better make sure it gets done. And so they did not even try to did not even try to personally deliver it. So I think that's a moot issue. Whether or not y'all were closed, I don't know whether you were closed or not.
Well, as I understand it, if it is stamped when we receive it, they mailed it purportedly on Monday the 30th, Tuesday the 31st, April the 1st. And so if in fact the DOR was closed on April the 1st or thereafter, you're saying that doesn't make any difference?
I see. Your point is that it may have been received on April 1st that you did not know. I understand.
Right. And DOR, there was nobody here to stamp it that it was received. Now, again, that's all subject to confirmation.
Yeah. I don't. There's no evidence of that. Number one, just because the office is closed doesn't mean that you're not receiving that you're not receiving mail or have somebody processing mail the date that it's received.
Well, which goes back to my question with regard to Mr. Adden, which goes back to my original question of what is your position with regard to us taking judicial notice on whatever we may find out?
I don't believe you have sufficient information to take judicial notice of the closure or the lack of receipt by the PTC of mail. This actually, the letters that are attached to that went with the appeals, the notices of appeal, were mailed to the Property Tax Commission at its P.O. Box 871. They were not mailed to the Department of Revenue building there. And so I don't think there's evidence that the PTC was not receiving and processing mail in a timely fashion. And so you can't take judicial notice. You cannot take judicial notice that, but for COVID, these would have been received timely. There's no evidence of that.
And are you in the position that it'd be improper for the PTC to look into whether, in fact, somebody was picking up the mail the week of April 1st?
Yes.
Okay, care to expound on that at all?
Well, I mean, and if we're going to get into additional evidentiary hearings, then obviously we need to continue this thing and have some kind of have somebody do an investigation of what was going on at the Property Tax Commission that first week of April.
Okay, thank you.
And if anything, if the commission is inclined to lean that way, then I think you have to put these. Yeah, you'd have to continue these in order to determine what was in fact going on regarding receipt of mail that was sent to the Property Tax Commission at its P.O. box that week.
All right, well, let me ask you this question, Mr. Haddon. If we can in fact determine whether or not there was somebody, whether it was closed, also whether or not somebody was here to receive, but also whether or not the mail was being picked up, if we could determine that from our staff, you still want to continue it to go into further evidence as to that?
No, I'm not inclined to continue, and I think the issue, the burden of, they've not come up with any evidence, so I'm not inclined to continue it, but obviously y'all have discretion to do that. But the issue also becomes, I know it's important, even when offices are closed because of snow days or stuff like that, usually procedures are set up to segregate mail as it comes in by days. And so even if nobody is there on April the 1st picking up the mail on that date, usually there's somebody that is processing mail and segregating it. And so you'd have to look into that. Did these envelopes arrive on or before April 1st? And that's, the evidence that is before the commission is that they were received on April the 6th. That's what the evidence is. And I haven't seen anything to the contrary. There's no evidence to the contrary.
She has raised that issue, and you were not aware of it, but it is newly discovered, and it is something that's probably available to the commission to look into to see, and perhaps we can talk about that a little later. Anything else in your response, Mr. Haddon?
No, that's all. Thank you.
Ms. Hillis, you raised the issue about whether or not the board had the authority, the assessor had the authority to delegate the mailing. And you referred to 105, I think 322 in your response. Can you talk about that a little bit more as to why you say they don't have that authority?
Sure. So 105, 322. So the Board of Equalization and Review takes an oath. They take an oath to carry out their duties. And so that's not something that South Data does. And so when the statute is very specific and says mailed by the board, we believe that that's very important, that the legislature chose those words particularly. It didn't just say the day the decision was mailed. It could have used other terms which didn't require the board to act. And so they have the ability to delegate duties to their employees and to help with appraisals if they need help with outside appraisals and those kind of things. But we do not believe that it gives them the duty to actually mail the decisions that the board does. Because, I mean, there is no question that we got the decision. Our position is just that we got it much later.
That you got it much later? What do you mean by you got the decision much later?
So the decisions, our office closed in Atlanta on March 13th. As of March 13th, they were not physically in our office by the mail. So I came in on March 27th, prepared the notice of appeal, and then filed it on March 30th. And so when it came in after that, I'm not, unfortunately, they didn't stamp it the day it came in. Because we were closed due to COVID, due to a lot of our staff being high risk.
All right, Mr. Adams, do you want to respond to that issue?
I would just point out that on 105-322D, the assessor is the clerk to the board. The assessor contracts with South Data to mail out board decisions. The requirement is the board shall notify the appellant by mail as to the action taken. The appellant was notified by mail of the action taken, no question. Ms. Hillis had those documents prior to the 30 days. She had plenty of time to respond to those, to prepare the notices of appeal, and she did. And the simple question is, the fact is, she mailed them using a Pitney Bowes stamp, and that is not sufficient under the Bass case.
May I add one thing?
Sure.
Under 105-322, I believe it's G3. It allows BOE to appoint committees and other persons to do. It lays out what exactly that they can delegate their duties for, and it nowhere in there says that they may delegate their duties to mail their decisions.
All right. Well, is there anything that you know that prohibits the board from delegating an administrative act?
I would submit that if the statute goes so far as to delegate or to specify what they may delegate, that it is presumed that anything that is not specified is not allowed to be delegated. It'd be different if they were delegating it to some employee of the Board of Equalization and Review. But this is them delegating it to the board or to the assessor's office, and then the assessor's office delegating it to some third party who has not properly authenticated their records. I believe that goes too far.
All right. Questions from?
I'd like to clarify. I would like to clarify something.
Okay.
The Board of
Mr. Adams?
Equalization. The Board of Equalization and Review is made up of members of the public that are appointed by the Board of County Commissioners. The Board of Equalization and Review does not have employees, unlike the Property Tax Commission that has the Department of Revenue employees acting as its counsel and staff. The local boards do not have employees. I don't know how the local board is going to mail a decision if it doesn't if it doesn't use the services of the assessor's office, and the assessor's office has the ability to contract with a mailing service. When you're mailing as much mail as we do, the assessor is the clerk to the board, has the authority to delegate. If I had an affidavit from the assessor saying these were mailed, the reason the affidavit is from Brooke Millard with South Data is because they are the ones that are responsible for the mailing. They're the ones that do it. They're the ones that send the notices out. And there's no question that these notices were sent to the taxpayers. And again, the actual board cannot, there's no way for a quote board to do what she says the board has to do. You have to delegate. You have to have people that do the mailing. And the person responsible for overseeing the mailing of these decisions was Brooke Millard. She said so in her affidavit. She's reviewed the records. She has a screenshot of the records that shows that these were mailed out, and it's clear that they were mailed out and received in time. And it's just an attempt to, well, I want to blame somebody else for the fact that this was mailed wrong.
All right. Mr. Peasley, Mr. Guest, any of the other commissioners? I may have one or two more questions, but y'all have any? Mr. Peasley, Mr. Gass?
I do not have any. This is Alex Guess.
All right. Let's see, let me ask, Mr. Pelfrey, it seems like, I remember there were some times that the building was closed. Do you have information, about the building and this time frame, and was it closed, and was somebody here to receive? And also, was the mail being picked up? Do you have information about that, or does maybe Ms. Bendette,
Mr. Chairman, I don't have specific recollection of when the building has been closed during the course of the pandemic, but I can tell you that as far as mail receipt policy, what commission staff have done is say, for example, the building was closed on March 15th and reopened on March 20th. What would happen is all mail that was received on March 20th when the building reopened would have been stamped as if it was received on the first day closed. So the purpose of all of that was to treat, to make sure that there were no issues relative to the building being closed that would affect people mailing their notices of appeal. In fact, anybody who inquired, we did have, there are local attorneys who prefer to file by courier, and we encouraged all of them to file by mail with a postmark in compliance with the statute. But again, everything that was received, all mail that was received on the day following the building being closed for some period of time was treated as if it was received on the first day closed.
okay. All right, thank you.
Mr. Chairman,
Yes, Mr. Wheeler.
what is,
Vice Chairman Wheeler.
we received this appeal and it had a Pitney Bowes on it. What is the date, Steve, that is stamped as received by the commission?
Mr. Wheeler, the date that the letter in each of these three related appeals, the date in which the appeal was received was April 6th, 2020, in an envelope bearing a Pitney Bowes meter label, but no postmark.
Okay, thanks, Steve.
I'm sorry, I
Steve,
muted
I
my
can't
mic.
hear anybody.
Yeah, I'm
Oh,
sorry, I
okay.
muted my mic to try to help out when Mr. Pelfrey was talking, so we didn't get feedback. And what I was doing, Ms. Hillis, I believe it was you that mentioned something about a recent filing that indicated, in your opinion, that we were a trial court. It was something that you gave a 2020 reference number. Can you expand on what your argument was there? You're muted.
Sorry,
Ms.
I was
Hillis.
doing the same thing.
Okay.
So yeah, so our argument is kind of threefold, that the PTC itself holds itself out to be a trial court. It's on your website. It is in the handbook put out by the Department of Revenue. It is also
Okay.
in a case by the Court of Appeals. It was against Mecklenburg County. Let me find it again.
Yeah, I'm familiar with the handbook. You indicated that, and we got a copy of it. I don't think it may not have been included in what got copied, but we got a copy. I think everybody has a handbook. But
On
the Court of Appeals is what I'm talking about.
Yes, sir. So it is in the Henry Harris Teeter appeal, and Court of Appeals case number was COA 19927. When I pulled it up in Fast Case, unfortunately, it did not have its like Southeastern reporter yet. But it was a North Carolina appeals in June of 2020, and it's COA 19-927. And in the concurrence, he says the PTC is a trial court, and that wasn't disputed in the majority opinion, but in the concurrence.
Okay, that was a concurring opinion?
It was.
Okay. And I think you mentioned that, but I didn't get everything, and so I want to be clear on that. Okay, further questions from commission members? I take it Mr. Peasley and Mr. Guest did not have questions either. All right, I'll give you a chance to briefly wrap up your comments. Anything else you'd like to add, Mr. Adden, and then Ms. Hillis?
No, I don't have anything further.
Okay, Ms. Hillis?
I would just like to say, thank you everyone for your time this morning, and that, that the statute is very specific and the legislature is very clear that each word means something. And in the statute, it says the date the board mailed the decision. The evidence is clear. The board did not mail the decision. The affidavit put in by Mr. Adden does not meet the hearsay exception for business records. It's missing all the foundational information. And also that all of these orders, we are in unprecedented times. There's a pandemic that wanted to, keep people from going out and spreading this virus. And so every deadline, whether we're talking about the governor, the Supreme Court of North Carolina, the General Assembly, the Office of Administrative Hearing, all of those deadlines were extended. So if this body finds that its deadline was not also told, it would practically be the only deadline in the state of North Carolina in this time period that was not extended. Thank you for your time. We very much appreciate it.
Mr. Adden, one last thing I forgot to ask about, and that's what she just referenced. The affidavit and whether or not it needs to qualify for the business records exception issue. Can you briefly talk about that?
Yeah, she states Ms. Miller states in her affidavit, she has personal knowledge of the matter set forth here, and based upon my own personal knowledge and based upon my review of the business records of the South Data of which I am familiar. Then she goes on to state that South Data received these BER decision letters dated March 2nd, showing the notices, and that the business records of South Data show that they were mailed on February the 28th, and so that they do. She says in the first paragraph, these affidavits based on her personal knowledge and upon her review of the business records of South Data. She says part of her job description is to oversee the mailing of documents for the Mecklenburg Assessor's Office, including the mailing of notices of decision for the Board of Equalization and Review and the mailing of notices regarding real estate values. She goes on to state South Data received these decision dated letters for printing and mailing. She personally reviewed the print file that was submitted, and the attached notice of decision was included in this batch for processing. She's clearly referring to business records that were done in late February, early March. The business records were processed and mailed on February the 28th. And then she says specifically these letters that were attached were delivered to the postal services for mailing with proper postage thereon. She addresses all of the information needed to certify that these decision letters were mailed out to the taxpayer and to the taxpayer's tax rep on February the 28th.
All right. And it does refer, I think, as you said, to the business records. All right, there you go. Okay, I found it. Something I was looking for. Okay. If there are no further questions or comments, then we will go into deliberation. and see if we can decide these three matters, and then we will be back before you, shortly.
May I have one
Thank you.
comment?
Ms. Hillis, did you?
Yeah,
You
yes,
have a
one
question?
quick comment. So yes, Mr. Adden is correct that it says that upon her review of the business records. But then again, when it's talking about that things were batched and processed, she doesn't claim to have personal knowledge that those 4,000 pages were indeed mailed on that day. All it says is that I reviewed the business records. In order to meet that foundational requirement for that portion, for which is the most important part of the affidavit, section 4, section 5, she would have to say that, they keep these records in the ordinary course of business, that it was that they were done by someone with information, that they were done at or near the time. None of that's in there. With that said, we don't think that they can beat the business records despite the initial clause that says it's a business record. Thank you.
All right. Okay, we'll, go into deliberation, and we'll be back, before you, shortly. That is something. Can I take a picture of that? Okay, we're going back online, it looks like. Ms. Hillis, I see, and Ms. Garrett, I see, and Mr. Adden, I see his name, don't see you yet.
I am here.
You're on the phone.
Video should be starting up. Yeah, the video ought to
Okay,
be starting up.
all right, we hear you, and so we can go ahead and continue. Okay, after hearing the arguments on the motion to dismiss, Mecklenburg County's motion to dismiss these three cases, the commission has voted unanimously to grant the county's motion in P&L Coliseum LP 20 Property Tax Commission 0241, P&L Coliseum Residential Developer LLC 20 PTC 0240, and POP Pop Capital Towers LP 20 Property Tax Commission 0239. And the vote was unanimous in each case. Let me say, Ms. Hillis, you raised a lot of interesting issues, did a great job in presenting them and what you had. The commission does not feel it has the authority under any of those issues to grant relief. If we did, we would probably be inclined to be favorable towards your position, but we don't see that we have any authority. We recognize that things during this period of time were topsy-turvy, but our mandate is statutory, and it says we do not have jurisdiction if that statutory receipt of the appeal is not met. So without jurisdiction, we cannot grant relief. But thank you for your arguments. And Mr. Adden, thank you. And if you want to join us tomorrow, Mr. Adden, to test your system again, that would be fine. All right. Thank y'all very much. Yeah, we're going to get to that right now. Yeah, we're going to bring on the other person, Ms. Phyllis. You're welcome to stay on as a participant, but we've got one more matter we have to hear. And obviously, Ms. Phyllis, you know you have appeal rights to the North Carolina Court of Appeals, and it may be that they could find some relief in this, but we don't feel we have the statutory authority.
Thank you. So will decisions just be mailed to my office?
Yes, sure, it will be. Certainly within 90 days, but probably quicker than that.
Okay, thank you. Thank you, everyone, for your time. I appreciate it.
You bet. Thank you.
Thank you. Thank you.
Ms. Rendrick, we're going to bring you on as a participant. Let's see where that gets this. Ms. Wiggett?
Hello?
Yes, now we can hear you. We do not see you. Do you have video?
I'm sorry about that. I'm sorry that you're not seeing me, but I am seeing you. And thank
Okay.
you for your time.
I didn't get your last comment.
I said thank you very much for your time.
Oh, okay, got you. Well, you're welcome. First thing I need to inquire is for a business entity, a designated person that meets the qualifications of the statutes can appear on behalf of the business entity. In this case, the representative named in the form that was submitted to AB 63 names Alpar Kumar. And is he present?
She is not, she is traveling.
I'm sorry, then, Ms. Wingate, you do not have the authority to represent the taxpayer, Royal Panthea LLC, which is in this matter 20 Property Tax Commission 0237 here from Mecklenburg County, and Mr. Adden represents the county on a motion to dismiss.
We had provided a power of attorney back when we first filed. Is that not relevant to?
It doesn't, it would have to designate you, and you would have to come under one of the persons who can be designated. Unless you're an attorney representative. Are you an attorney?
I just need to ask you a question.
All right, we'll see if we can answer that question. Yes, ma'am.
Thank you. So, can she?
Next year? Next year, Mr. Adden, do you agree she would have the right to appeal next year?
Oh, yes, any taxpayer can appeal either in a year, but yeah, she would have the right to appeal in 2021, provided
Okay.
local appeal to the Board of Equalization and Review prior to the board's adjournment, which will be sometime in May 2021. And of course, that would only apply for tax year 2021.
Right, and going forward. Okay. Mr. Wingate,
Yes, sir.
that is correct as I understand it. And I would point out that, you know, if we continued the matter, it appears from Mr. Adden's motion and his affidavit that the receipt was late here. So unless there was something that's showing that it was postmarked with the U.S. postmark on it on or before April 1st, or it was delivered here on or before April 1st, we would have no way to grant relief. So a continuance would not do you any good that we're aware of. So, but you would have a right, the company would have a right next year to file for a appeal. And I'm sure if you had questions about it, Mr. Adden or somebody would be able to tell you about the timing on that. Okay.
I would like to point out one thing to Ms. Wingate.
Yes.
Ms. Wingate, on this is just an aside, but on the AV-14, the taxpayer says that the value was a little over $2 million. In effect, the Board of Equalization and Review reduced the value from $2 million to a little over $1.3 million. So I'm not sure if the taxpayer understands correctly what was at stake. The the property was reduced by the Board of Equalization and Review to just a little over $1.3 million. So I just point that out to her before they go and appeal for 2021.
Yeah. Yes. Yeah. But we-
So the just price.
Okay. All right. So in this matter, the county has filed this motion, and we have it. Anything else you'd want to add, Mr. Adden? There's no one here to appear for the taxpayer and that can legally appear. We have your motion and affidavit.
And I would just point out at least the envelope that I received was a Pitney Bowes. It was mailed using a Pitney Bowes machine, and the envelope I had it was mailed on April the 2nd, which would have been a day late anyway. So it's late in multiple reasons. Thank you.
All right.
Thank you.
Questions from commissioners? Hearing none, do we have a motion in the POP Capital Towers LP 20 Property Tax Submission 0239?
Commissioner Chairman.
Is that Alex made? Yes,
It was
Alex.
Alex, yes. Can Steve just read into the record the dates all of our documents were mailed out and just get all that on?
Okay.
Thank you.
Sure.
Yes, sir. Mr. Gales, Mr. Chairman, just to be clear, this is the Royal Panthera LLC.
I read the wrong one. Thank you.
Sure.
Excuse me.
File number 20 PTC 0237. According to the county motion and documents filed in connection with this matter, the Board of Equalization and Review heard this matter on February 13th, 2020. A decision was mailed on February 28th, 2020 from the board to the appellant. The letter was apparently, that is, it was marked as being mailed on March 2nd, 2020. Presuming that to be correct, the due date of the appeal would have, to the Property Tax Commission, would have been 30 days later, or Wednesday, April 1st, 2020. The letter was, the notice of appeal was actually filed by the appellant with the commission on April 6th, 2020. It was received in our office in a letter bearing a postage meter label, a Pitney Bowes postage meter label, which carried a date of April 2nd, but there was no postmark on the envelope. So this was deemed to have been filed on the date received, April 6th, 2020.
Okay, and just to make sure I correct the record, this is in the Royal Panthera LLC 20 Property Tax Commission 0237. That's before us from Mecklenburg County, and Mecklenburg County represented by Mr. Adden, and no one properly here to represent the taxpayer. All right, now, further discussion. If not, do I have a motion in this case?
So moved.
Yep. Have a motion by Vice Chairman Wheeler to grant the county's motion to dismiss, and Commissioner Michaud seconds. Any discussion? Hearing none, all in favor of the motion to grant Mecklenburg County's motion to dismiss, say aye. Aye.
Aye.
Vote nay. Okay, the matter is dismissed, Mr. Adden. So I think that clears us
Thank
until tomorrow morning. And so unless somebody has something, Alex, you have something?
No,
No?
sir. I'm
Okay.
good. Thank you.
All right, we'll see y'all in the morning at 9 o'clock. Thank you very much.
Thank you.
Okay. All right, I'm going to go ahead and see if I can join this thing and stay here. We're through until tomorrow, right, Steve?
Yes, sir. Steve, if I was, I'm talking about commission